Good evening, everyone. It is great to be back in person in Mumbai. India is one of our most important jurisdictions. We have been coming here for a very long time. Obviously, you would see from our statistics the number of Indian parties that are using SIAC arbitration. And quite relevantly, the number of Indian parties that are involved in emergency arbitrations. In the last 3 years, 183 Indian parties have been involved in emergency arbitrations. Since the provision was introduced, we've received 134 applications. So it is a very relevant procedure for this room. And I'm very pleased to be joined by experts across the board who have been involved in many of these SIAC emergency arbitrations and SIAC arbitrations generally. There is arguably a quartet, that's better. Now, now we can really hear me. There is a quartet of SIAC emergency arbitrations that have wended their way through the Indian courts. The panelists have been involved in all 4 of these emergency arbitrations, so we'll be very privileged for their observations and practical experience. Rather than running through introductions, I would refer you to the program, and I would thank the organizers for putting me between the Deputy Chairman of the SIAC Board of Directors and a member of the SIAC Court of Arbitration. So let's get into how this actually works. Ileong, I will start with you. What are the circumstances where you might make an application for emergency interim relief? When is it green light?
Well, I think the most important point about emergency arbitration is that you need something on an urgent basis, and the ground on which is that if it's not granted, irreparable harm will be caused, and that irreparable harm cannot be compensated by damages. So if you look at that, the usual application for emergency arbitration would involve matters such as shares of companies. Sometimes if to prevent someone from disposing of shares, I think we all know a very, very prominent case that recently, the Amazon and Futures, where one party was restrained from disposing of their retail assets pending the arbitration. And they are also, in terms of my area of practice, which is the construction infrastructure practice, a very common area is to restrain the call of performance bond, right? When you have performance bond issued to secure the performance of EPC contract, regularly you get application for injunction to restrain. And recently I have been involved in a case where there have been an application for emergency injunction, emergency arbitration for to enforce a negative pledge in a lending instrument. In lending instruments, regularly you have pledges to say that the borrower will not dispose of certain assets, will not dispose of certain shares, and then in that case, an emergency arbitration was brought to enforce it. Those are some of the common cases that you come across in terms of emergency arbitration.
Yeah, the call on the bond is a very common one for us. It is an old joke in emergency arbitration that these applications come in on Friday evenings, but they do. The eves of holidays, Friday evenings. So the Secretariat is often working over the weekend. I can see one former member of the SIAC Secretariat that once worked very deep into the night. We turned around an award overnight because there will be a call on a bond on Monday. So the institutional rules differ. Under the SIAC rules, you have to make an application at the same time as the notice of arbitration, so it can be concurrent or after the notice of arbitration, but prior to the constitution of the tribunal. Tejas, in terms of the practical getting up, I think most of us in this room understand the doctrine, but what are the practical aspects of making an application for emergency interim relief from the claimant side?
Thanks, Kevin. Good evening, everyone. It's always a pleasure to be part of SIAC conference. Just to answer your question, it's a very practical question which comes to our mind is that not in every arbitration that we have to invoke emergency arbitration. Firstly, we need to see as a claimant whether do we need an urgent interim relief. As we heard, we have to establish that the relief which we are seeking cannot wait the constitution of the tribunal. Secondly, we need to see whether you would like to go to national court to get a relief if you want an ex parte relief, or you would like to invoke emergency arbitration. Once we have made up a decision that we have a good case to make an emergency arbitration application, the procedure has to be followed fully. In terms of what is the nature of relief, what are the grounds on which we are asking for a relief, prima facie case, and also we have to see that what loss will be suffered by the party if emergency relief is not granted. We have to serve a copy as far as SIAC rule is concerned, and we need to see that the fee is deposited simultaneously. Many times in practical experience, we have seen that you serve the other side, but you don't know how to remit the fees to SIAC, and that takes 3-4 days for doing it. So as a claimant, we need to prepare everything in advance to know that you have the authorized signatory, you have the payment sorted out. And also, we need to keep it in mind the responsiveness, because it's quite possible that the jurisdiction can be challenged. There could be another issue with regard to which is the seat of arbitration. All those aspects have to be kept in mind, and all the responses which to the objections which may come from the respondent should be kept ready from the claimant side, because 14 days is a fairly short time, and SIAC, as we all know and we have heard and experienced, acts very fast in terms of appointment, and so as the emergency arbitrators. So as the claimant and the counsel for the claimant, we need to be fully ready to make the application which is successful. We have seen in experience that if you don't think it through, as the claimant before making in the emergency arbitration applications, sometimes it's counterproductive. And we have had cases where parties had to withdraw arbitration after being unsuccessful in emergency arbitration application. So it's a tricky thing, but it has to be done very systematically.
If I could just stay with this for a few moments, would it matter, for instance, if there was a sole arbitrator tribunal versus a 3-member tribunal? Because you might be able to get a sole arbitrator up reasonably quickly. It's almost a question of how urgent is urgent. And would you also think about the jurisdiction of the counterparty when you're deciding whether or not to go for this mechanism?
Yes, definitely. We prefer sole arbitrator, and that is much faster in terms of the cost, and also in terms of getting the dates from the arbitrators. But eventually you have to really see that how important is to get that interim relief even before the appointment of a sole arbitrator. And depending on the jurisdiction, the enforceability comes a big question, is that even if you get an interim relief through emergency arbitrator, whether you would be able to enforce it or not is a big question. India has evolved over a period of time. Now, at least for India-seated arbitrations, we have the emergency arbitrators orders enforced under Section 17(2). But before that, we didn't know, and we tried twice. I was part of the Law Commission Committee who advised the changing the definition of arbitral tribunal to include emergency arbitrator, but we have been unsuccessful so far. So at least we have one Supreme Court judgment which supports the enforceability. Yes, the jurisdiction of the counterparty makes a big difference while making a decision whether to move for emergency arbitration or not.
You make a good point about making sure that the deposits are in and ready. That was part of the reason why we updated the SIAC rules 2016, was to make it a flat fee of 25,000 Sing, so you don't have to go through the process of quantification. Generally, any applicant, the moving party, will usually let the institution know that, hey, we've got this application coming in, and this allows us to make preparation so that we can be ready to appoint, as Gloria said in her opening, in a matter of hours. Raj, sometimes the unenviable task of being on the other side, respondent side, you get a wheelbarrow of documents that you have to respond to very quickly. Obviously, these timelines are fast, 14 days from the appointment of the emergency arbitrator. What is the strategy and the thinking from the respondent side?
So it's always challenging for a respondent when he gets an application for emergency award, and he's always at a disadvantage because he doesn't have as much time as the claimant had to prepare his application. So if he's anticipating some kind of an application that may come in, he needs to be ready with his response, a draft, or maybe a proper succinct list of dates and events which becomes easier when he has to respond. I would also feel that many a times you are at such, you have notices at very few short periods. So you keep your responses and the drafts and the submissions that you make it to the point, keep it succinct so the tribunal is not getting confused. At the same time, you're putting your points across and you're ensuring that you're creating as much hurdle as possible, or making it as much more difficult for the tribunal not to just grant him the reliefs. Of course, you will of course look at whether there is any jurisdictional issue or any procedural failures that has taken place by the claimant, and you would take that as your defense as well. But generally, I would advise that be prepared, anticipates that there may be an emergency application, and be ready for it.
I mean, the jurisdictional issue for emergency arbitrators is interesting. You could have a situation, as we see in some cases, where you have a non-signatory. So you might have multiple respondents. One is a signatory, one isn't, and this emergency arbitrator quite early with limited submissions is having to decide on his or her jurisdiction. Is that a point that you would press from the respondent side?
I would. In the initial, at least, I would bring that point up, and maybe the tribunal may say that we'll decide later, but I would bring that as a point that it's a non-signatory to an arbitration, and as an emergency arbitrator, to pass an award against a non-signatory would be difficult.
Thanks, Raj. Prakash, you have been coming to India forever, and certainly have been involved in SIAC arbitrations. One of the most talked about issues, and certainly relevant when choosing between an emergency arbitrator or an application to court, is the test. So what is the applicable test for the grant of interim relief? How do you view that from counsel side and as arbitrator or emergency arbitrator side?
Thank you very much, Kevin. Yes, I've been coming to India forever, but for 2 years I've not come, so it's very nice to be here, to see so many faces and friends again. Just in case you're wondering, just a preliminary point, just in case you're wondering why I'm the only one not wearing a jacket and a tie and all that, it's because, I heard maybe from one of my Indian friends that you can be particularly effective on stage if you dress like an Indian politician. So let's see if it works. Now, on the test, that's a very, very interesting point because it's one that I think we are heading towards some kind of consensus in the arbitral world. The starting point, obviously, is that the rules don't prescribe a test. So what do? You look at the seat. The legislation may or may not. Singapore, it does not. It just gives the tribunal the power, but there's no test. You look at the model law. 85 says nothing. 2006 talks about it. It prescribes a sort of American cyanamide sort of test, which talks about things like irreparable harm, and cyanamide is a serious question to be tried. Different language, similar sort of concepts. But and you can also look at this, arbitral institutions like CIAB. They also talk, in similar terms of incorporating points of, firstly, you have to show you have a case, reasonable prospects of succeeding, and secondly, there's some sort of balance of convenience. Who does it prejudice more? But in the transnational world, Gary Bond, former head of our SIAC court, he's championed the transnational approach. And there, it seems like the test is deliberately a little bit more flexible. It starts off with a prima facie case, and it also talks about things, well, according to him, he says, whether the claimant will suffer serious or irreparable harm if the emergency relief is not granted. So serious or irreparable harm. So it gives some, you can see that, it gives some flexibility when you are looking at concepts like balance of convenience and so on. But the true importance, I think, of a transnational test is demonstrated in the, it was a very famous case about 7-8 years, or maybe a bit more now, the GMR against the Maldivian Government case, which came to Singapore. So there was no emergency arbitrator provisions because they used the answer trial rules. So what the GMR did in order to stop the Maldivian government from taking over a concession and kicking them out of the airport was to apply to the Singapore court for interim relief, for an injunction. And there, the court, applied the American cyanamide, denied the injunction, and one of the key considerations was that it didn't want to sort of supervise a foreign land. It found that an unacceptable thing. So now, if you think about it, parties have agreed to international arbitration. Would a tribunal similarly do the same thing? I think writers have spoken about it, and I think the general point is that perhaps not. So when you bargain for arbitration, these procedures help you in a number of ways. They make it more flexible, and if a tribunal truly adopts a transnational approach, such considerations about caring about what a foreign government thinks would be less important.
How about Leong?
Sorry, if I may just add again a favorite topic of mine, which is the injunction to restrain performance bond, right? When you go to court to try to get an injunction to restrain the call on a bond, I think English law is very clear. It will not grant an injunction unless there's fraud involved. Now, in Singapore, we have expanded that a little bit more to say if it is fraud or unconscionability, then the court will grant an injunction, otherwise no injunction. It is not clear when one goes to before arbitral tribunal what is the standard that you apply. In fact, I have a number of cases where it's been pretty inconsistent. Some tribunal applies the standards that I think Prakash has talked about, which is, irreparable harm and damages is not sufficient remedy. If you apply that test, then obviously you won't grant an injunction, because if you call on it, you take the money, and then obviously money can obviously be paid back, okay? But in performance bond, there is always a special consideration. If you all remember Lord Denning's statement in his judgment that, letter of credit, from which performance bond derive, is the lifeblood of commerce. And you cannot really jam up the payment. So that's why they come up with the fraud exception. But in international arbitration, that is not clear yet at this moment.
Sorry, I forgot to say something in relation to the applicable tests, and that is when you consider the different types of injunction. So broadly, prohibitory versus mandatory injunction, one to stop something and one to compel something. So is the test going to be different? Now, if you look at the common law, under English law, the famous Rover Films case, where Lord Hoffman was talking about that, he was saying in the context of a mandatory injunction, the risk of injustice is greater because you very often are giving the final relief and you're doing something which may be unalterable. So a higher degree of assurance is required. So how does that translate into sort of in the international arbitration context? So this is where I think tribunals, in my experience, are equally sort of sensitive about the difference between the two. So we had a case where we were acting for a Thai airline against engineering company that there was a maintenance of engine contract, service contract, that was allegedly breached. And there are two parts to it. Some engines, the agreement was terminated, and some engines were given to another service provider. Some engines they still kept. So the engineering company, had an application, an emergency arbitration application for a prohibitory and a mandatory injunction. And they were successful on the prohibitory one, but not on the mandatory one. And and they were not very clear about it, but my suspicion is it's Rover Films, haunting them, because there is a difference. The concept of justice is, permeates through that as well. Sorry.
Not at all. Leong, the harm not compensable by monetary damages, how does that fit in with reputational risk? You see a few commentators that say that might end up being irreparable because of the reputational risk. Any views on this? And I partly ask because you have done so many of these SIAC emergency arbitrations.
Right. Well, I think the traditional view is that reputation should not be taken into account when you look at what harm is caused, because if every time you take into account a reputational risk, obviously then it is something that is difficult to compensate by money. But I think more and more parties are trying to use that at application for emergency injunction. Sometimes it works, sometimes it doesn't. I think it depends on the tribunal, but the conservative view, and I personally subscribe to it, is that it should not be a factor to be taken into account.
You know, just for the benefit of the audience, we should release the transcript of our pre-webinar call because all of the thoughts that we canvassed there, really fascinating. Suyen, looking over at you, of course, you have an active practice in the Singapore courts, arbitration council, and as arbitrator, assuming that you have a valid and existing arbitration clause and you need urgent relief. How do you make the choice between choosing an emergency arbitrator or potentially going to court? And this is in the Singapore context.
Thank you very much, Kevin, for that question. I think it is very important when we look at the question of interim relief to decide whether to go to a national court or to go to international arbitration, to look at it from three main factors. The first is that of parties. So who are you trying to apply for the interim relief against? For instance, if you're trying to restrain the call on a performance bond that's issued by a financial institution, by an insurance company, that is not a party to the underlying arbitration agreement, which is the main contract between the developer and the main contractor. If you go to an emergency arbitrator and you try to apply for the restraint of the call, putting aside the difficulties that you have to establish the test of irreparable damage, are you really going to be able to convince the emergency arbitrator to grant that order? And even if you do, what is the level of enforceability that you have vis-a-vis a financial institution, a bank, which is not a party to the arbitration agreement? And most financial institutions and banks would say, unless you show me a court order, I am going to pay out on the bank guarantee or the performance bond which has been called upon. So the first thing to consider is really, who is the party you're seeking the interim relief against? The second thing that I would say, which is very important, is urgency. How urgent do you need this interim relief? Is it a situation where you're trying to preserve evidence, where it's critical? Is it a situation where you're trying to get a river injunction, where you're trying to freeze assets, and you can't give notice to the other side? Is it a situation where you need it, just like a call on a bank guarantee? Within 1 day, the bank will pay out. It's unconditional, it's irrevocable. And if that's the case, much as SIAC is extremely efficient, we have a situation where you still have 14 days for the tribunal to issue the award from the time of being the emergency arbitrator, 14 days to issue his or her decision. You have to give notice to the other party, which in a situation where it's so urgent, you just can't give notice to the respondent. So like a river injunction situation, like a concern where you want to preserve the asset or the property. So when you can't even give notice, you would then think, I want to go to court because I want to go ex parte. And I have a concern if the SIAC rules as they currently stand, if they do not allow a tribunal to grant any ex parte interim relief, that it will eventually not be recognized or enforced by any court because it's in breach of due process. And the third thing I would say, which is critical, enforceability. So enforceability of that order, much as an emergency arbitrator can grant an order against a non-party if he or she exercises certain doctrines, even the group of companies doctrine, to say that someone in the company is bound, and I'm sure we'll talk a lot about the Reliance and Amazon case, but where's the seat of that arbitration, and would you be able to enforce it in the right jurisdiction? So I think these are three very important considerations that I would think about, and then I'll decide which best achieves my client's commercial objective.
I guess the advantage that we have in Singapore is that the legislation is provided for the enforceability of these emergency arbitrator orders, so they're enforceable as though they're an order of the High Court. Raj, what do you look at from India? So emergency arbitrator or court, and I guess to either of you or Suyen, can you have sometimes part of the order will go to court? The language used in the Singapore Act is the institution unable to act effectively. Might some then be remitted to the emergency arbitrator?
So you see, this question of the tribunal unable to act effectively or no power, I think it ties down back to the point of urgency. If I need something immediately, I would want to go to court. I filed the papers in the Singapore courts. I can attend before a judge. I can get it the very next day when I cross all the threshold. Before an emergency arbitrator, because of this need for the respondent to participate in it, it's sort of, times gets delayed, unless you have the Swiss rules, which, you know, in exceptional circumstances, the Swiss rules, they actually do allow an emergency arbitrator to grant ex parte relief. So when you see that in an institutional rules, then perhaps, you know, there's an additional consideration that is an emergency arbitrator order better. So the unable to act effectively, I think, really ties down to the question of urgency and parties. Does the tribunal have the power to grant an order against a true third party like a bank or financial institution?
So in the Indian context, I would look at a couple of things. The first would be where the seat of arbitration is. Because if the seat of arbitration is, say, outside of India, and if you have an emergency award outside of India, to bring into India and to enforce it, you'd have to still go under the Section 9 mechanism to get an interim relief, relying upon the emergency award that you would have got in Singapore. Now that takes away a lot of your time to get the reliefs that you want. Would you want to wait for that long? But if you have an asset of that party outside India, and you can enforce that decision outside India, you may probably want to consider having the emergency award and enforcing it outside India. But if you want to bring it into India, I would probably advise my client, go to Section 9, take your reliefs, take an injunction, and then go for arbitration. But if it's an arbitration seated in India, in which, because of the recent judgment, now allows us to get that enforcement orders, I think more and more parties would probably consider emergency arbitration seated in India, so that it's now become enforceable in India. So that's very, very helpful. But otherwise, if an asset available outside India, go for emergency arbitration.
Yep. Naresh, staying with this same theme, is it possible to make simultaneous applications? So making an application for the appointment of an emergency arbitrator, also making an application to court. In effect, is there room for forum shopping? And also, given your experience, any observations on what we've discussed so far?
So thank you, Kevin. To begin with, contrary to what Prakash was told, I was actually told to dress as the politician's friend, and if I wanted to be heard. But, standing last in queue also is not the best thing to do. In the sequence of events, I'm the last, and the question put to me is one of the most difficult questions, as it always happens.
You should see the rest of my sheet. There's some more difficult ones here, and they're directed to you.
So, the answer to that definitely has to be no, that you ought not to be able to make two simultaneous applications, one before the emergency arbitrator, the second before the national courts. There have been two situations that I can speak of. One is obviously the English High Court in Gerald Mitchell, where the English High Court has held that you can go and make an application before the court under Section 44, only under exceptional circumstances. In Gerald Mitchell, nonetheless, what had happened was that an application to appoint the emergency arbitrator had been denied. And post that, the party actually tried to make an application before the court. The court actually refused to entertain such an application on the ground that these were not exceptional circumstances. And if I was to actually try and look for a equivalent case in India, one of the decisions of the Delhi High Court, which is in Ashwini Minda, having lost an application under emergency arbitrator before the emergency arbitrator, the party tried to make an application under Section 9 before the court. And the court in such circumstances held that you can't have a second bite to the cherry, and rightly so. So in my assessment, you certainly cannot make two simultaneous applications. There could be a situation where, nonetheless, you have lost before the emergency arbitrator, and yet you have gone before a Section 9 court seeking the same relief on the ground that what happened before the emergency arbitrator was not the most efficacious of remedies possible, which is the carve-out under Section 9, subsection 3. But that's an uphill task to my mind, and I don't think that's something which is going to be easily achievable.
So I suppose no simultaneous applications, but in emergency arbitration, you might be dealing with parallel proceedings. So a form of relief that we certainly see is an anti-suit injunction,
Absolutely.
potentially. Proceedings in the Indian court, Singapore seated arbitration, emergency arbitrator appointed.
Absolutely.
Yeah. Okay. Tejas, as one of the interesting things to me as a member of the SIC Secretariat, and these are things that you decide, is the interaction of the different procedures. So you have prima facie jurisdictional objections, consolidation, joinder. You decide all of these. How does it interact with an application for emergency interim relief?
So as a court of arbitration in SIAC, it plays a very important role in terms of deciding various applications. This could include if there are multiple contracts, the party has ability to file one notice for arbitration or multiple notice for arbitration. And in that case, the consolidation has to be decided by the court as per Rule 8. Rule 7 also talks about joinder of parties. Now, that the ground for joinder of party is that if the party to the arbitration agreement wants a party who is prima facie bound by that arbitration agreement to be joined. Now in India, we have a group of companies doctrine and there are various judgments on that, whether a parent company would be liable for a contract which is entered by the subsidiary and under what circumstances, if there is a common economic interest or not. And we also get number of applications for consolidation of the various arbitrations if there is a commonality and the grounds which are mentioned under Rule 8 are fulfilled. Now, when you're making an application for emergency arbitration and you have the other applications, it's bound to be an overlap. And we have a time limit under the emergency arbitration process of 14 days from the date of appointment of the emergency arbitrator. So that makes it also important that if you are making multiple application and there is a overlap between the same, then the court has to make the decision very, very quickly. And we do so. So it's very important that as a claimant, you are aware of this procedural hurdles, and as a respondent, if you are getting joined in an arbitration and a relief is being sought, the application for joinder has to be allowed before an emergency arbitrator passes an order. So these are the practical difficulties and the procedural hurdles which as the parties or as the SIAC court we are aware of, and then you have to make the application, because if we lose time on this applications or not make it properly, then it may impact the ability to get the emergency arbitrator's order in time. So that is something has to be kept in mind always while making the application, including mentioning all the facts in the notice of arbitration itself, so that it becomes absolutely clear for SIAC Secretariat to understand the position of the parties and can act swiftly on those applications.
I just wanted to chime in here to say that if I'm acting for an applicant and I'm trying to restrain the completion of a sale and purchase agreement of shares, and the contract that I have is with party A and party B and C are non-parties to the contract, but they may be the parent company and I want to bring them in, I probably would circumvent the joinder provisions and simply file my notice of arbitration, naming ABC as the respondents, and then in my notice of arbitration and in my emergency application, say why is it that if I simply restrain A, it is not effective, and B and C, because of the fact that they were, principals behind the negotiations of the contract, they had their legal counsel participate in it, they are the parent company, company A was just set up purely for the purposes of carrying out this project, that they are all prima facie bound by the arbitration agreement, either by the doctrine of group of companies or by consent, and through that not go through the joinder process, because otherwise I will lose time. Then, then I wouldn't go down that emergency arbitration route. Yeah, so just thinking if I was applying.
Yeah, I mean, thanks for circumventing our joinder provisions. But that is possible under the SIAC under the SIAC rules. You could array a non-signatory without making a formal application for joinder, and I think there are tactical reasons for it. One of the challenges that we have, so if a party does apply for joinder to the SIAC court, so follows the rules, doesn't circumvent, then we have to decide how much time for the party To-
Learn something.
we have to decide how much time, given the urgency of the application for the appointment of emergency arbitrator, how much time is fair for the other side to respond. Same thing in consolidation. And consolidation, if you think about it, particularly under the SIAC rules where you don't require identity of the parties, that's a fairly significant procedural decision to be making. So in the context of emergency relief, does that mean 3 days, 5 days to respond? Will that work with the urgency? So these are the kind of complexities that institutions are dealing with. So assuming we have an emergency arbitrator appointed, it's appointed within 24 hours, maybe 7 hours, maybe 4 hours, and then you have your emergency arbitrator order or award. Yi Leong, what do you do then, both from a Singapore-seated standpoint and a foreign-seated standpoint? What is the position in Singapore? How would you go about giving teeth to that order?
Well, actually, from my experience, most parties actually voluntarily comply with the emergency arbitration orders that have been granted. So it's not so often that we got to run to court to get a court order to get it enforced. But obviously, if you have to, in Singapore, it's actually quite simple and quite quick. You make an application under the International Arbitration Act, and it's made very clear that emergency arbitrator is defined as an arbitrator as well as arbitral tribunal. And also, order granted by emergency arbitrator can be enforced by application to court. So it's a pretty straightforward and simple matter. As far as emergency arbitrators orders granted overseas, that means that from foreign-seated arbitration being enforced in Singapore, I think the situation, unfortunately, is not as clear under the International Arbitration Act, because enforcement of foreign award or foreign orders come under Part 3. And under Part 3, there is no similar definition of arbitral tribunal being including emergency arbitration tribunal. So there is a question mark as to whether an order granted by EA amounts to an award or order that can be enforced under Part 3 of the Act. I think there are two schools of thought. Some people think that you can't, and some people think that you can. Unfortunately, it has not been tested in court. So that's the situation in Singapore.
Naresh, when I said that we were going to make you do some heavy lifting, this is where it starts, and I think this is the topic that we've been waiting for. In terms of, I understand that there is a very well-known decision. What are the consequences of that decision? How do Section 9 and Section 17 look? Indian-seated arbitrations, foreign-seated arbitration. What is the state of play now?
Yeah, so insofar as the India-seated arbitration is concerned, I think the heavy decision that you now talk about takes care of the situation. Once you have a order from the tribunal, and obviously one of the questions was that it's whether it's an award or an order. What's the nature of that instrument? The Supreme Court now holds that that is to be treated as an order. Insofar as the entity, namely the emergency arbitrator, is concerned, the Supreme Court says that it ought to be now considered as an arbitral tribunal. It is now housed under the definition of arbitral tribunal, so that takes care of it. And if that is so, then the order or interim order of the emergency arbitrator is to be considered under Section 17 of the Act, which means that under Section 17, subsection 2, the enforcement would happen as it would for any order, any interim order passed by the civil court under Order 39 of our CPC. But when it comes to a foreign-seated arbitration, things take an entirely different color. And as I think Raj pointed out, it would be very difficult to get that order actually enforced in India, because the problem truly is that if you were to look at Section 2, subsection 2 proviso, and as a lot, everyone out here possibly would be aware, that Section 2, subsection 2, in its unamended form, actually said that the first part of the Act would only apply to domestic seated arbitration, which would mean that there was a problem with the application of Section 9 to a foreign seated arbitration. which is exactly the point which was raised in the now celebrated decision of Balco, which finally settled the dust on this issue in 2012 and said that, unfortunate as it was, Section 9 was not available. The benefit of Section 9 was not available to any foreign-seated arbitration. Obviously, the 2015 amendment changed the scenario, and that is how the provisor to Section 2, subsection 2 was brought in. But the problem is that the provisor does not include Section 17 within its ambit, which yet means that if you get an order from the foreign arbitrator, or from a foreign-seated emergency arbitrator, the enforcement of that cannot be done under Section 17, subsection 2, and one will have to follow, as Raj rightly pointed out, the Section 9 route, which obviously is not the most efficient thing to do.
So for, say, an HSBC, Raffles Hotel, Mumbai, so would you then I think that SIAC was very successful in coining the term effective enforcement. So would that then be under Section 9?
Yes, it would be under Section 9, and I don't think truly that it would be a very effective method of going about it, because ultimately, when you filed a Section 9, it's not an enforcement mechanism, so it's not as if that you go to court seeking enforcement of an order which has been passed by the EA under Section 17. What you truly are now doing is that you're asking the court to have a relook at everything, and then you seek an order in terms of the Section 17 order which has been passed by the EA. So I truly don't think that it's a very effective mechanism in that sense.
Kevin, sorry. I think this will work. Yeah, that's right. Just to chip in here. So, as Kevin's point about me coming to India for a long time, so I've been, last decade we've been talking about very, very similar issues, Balco, Section 9, and so on. So it's interesting to see how this has evolved. It's not, Section 9, I love Section 9. I mean, when Balco came into being, I was so disappointed that Section 9 suddenly, disappeared from the context of foreign seated arbitrations, because, it's your way into the Indian market to enforce, an interim relief order. So even though it is not, and I totally agree, it's not enforcement, if you look at all those cases, HSBC and, Raffles and so on, I mean, there's heavy reference to the award made by the emergency arbitrator. So it's sort of like, we're supposed to do it separately, but we're looking at this and, in effect, what we're doing is we are going to follow it. And, Naresh mentioned the Ashwini case. I mean, I think that really demonstrated the case in a sort of inverse sort of way. Because there, the emergency arbitrator, didn't give them the interim relief. They then came to India, tried Section 9, and what did the court say? The court said, you can't have your second bite of the cherry. Once you have chosen this route, stick with this route, and so on. So it is actually telling you, that is enforcement in inverse. It is fidelity and respect to what the emergency arbitrator has done, which the Indian courts, endorse. So it's a Section 9, long live Section 9. I'm a big fan of your Section 9.
Kevin,
Sorry, if I may just also add to it, because I actually have a personal experience in terms of the Raffles education and EduCom. I see Calvin there smiling because he was my opposing counsel in that case where I applied for emergency arbitration orders, and I successfully obtained the order in Singapore. But it has to be enforced in India because the subject matter of the dispute was a school in India, and we have to come to India to enforce it. Now, if you look at the timeline of what's happening, when we started the arbitration, the amendment to Section 9 has not come in yet, the 2015 amendment to reverse Balco. But by the time we got the emergency order, the amendment has come into effect. And we took the order and we quickly ran to court, and Piyush Prasad was actually helping us, and he and his colleagues ran to court to get, in a sense, enforcement through Section 9. And 11 days after the emergency order was granted, we got an order under Section 9. So it was, in fact, pretty effective and pretty efficient.
So, these are one-off experiences. There are experiences which go the other way as well. And I must say that the Indian legislature wants to keep all of us in business. They don't want us to go out of business at all. And truly, twice over, there have been attempts by the Law Commission to say that emergency arbitrator actually ought to be brought into the provisions by themselves. But the fact of life is that despite two amendments, one 2015 and then 2019, that has not seen the light of the day. So, it tells us that, how the courts have been operating. There have been creative interpretations, if one can put it that way, that these interpretations are creative, but truly, the courts have been laying down the law insofar as your emergency arbitrator situations are concerned.
One of the important points in this Ashwini Minda case, I was involved in that, and one of the important point was that parties had by choice excluded Section 9. And having excluded Section 9 and lost the emergency arbitration application in Japan, they tried to come to India by filing a Section 9 and taking a second bite at the cherry, and that's when the objections were taken.
If I may just add, we have come a very long way in terms of enforcement of emergency arbitrator. First, we went to court and converted emergency into Section 9. Then we have now India-seated emergency arbitrator awards or orders being enforced. The next step, in my view, is that because Section 9 is available for foreign-seated arbitration and Section 9 refers to Section 17, Section 17 should also be 17.2 should also be applicable to foreign-seated arbitrations. That is the next step which we should achieve by way of judicial interpretation, because there is no logic that if you have been unsuccessful in emergency arbitrator, you cannot go to Indian court. But if you have been successful, you can go to Indian court. That is a wrong analogy which we are applying, and if Ashwini Minda is correct law, then we cannot apply that law for Rafales. And we have to extend 9 to 17, and there is no way we can see that there is any prohibition under the existing law. If you can have emergency arbitrators seated in India enforceable, the same way emergency arbitrators seated outside India should also be enforceable under 17.2.
So, the point is that, if you want the Section 9 to be extended, then truly, it will only be through a interpretation, again, to be given by the courts. And the best way, therefore, possible is to bring about the change in law. The question truly is that, is the legislature up for making that change in the law? Twice over, we've not succeeded. Why should, we have anything of a change again come about in the law? But Kevin, thank you. You truly asked a very difficult question. I had all my panelists to answer for me as well.
I think one of the most important takeaways is Prakash's love for Section 9. We have feedback forms, so feel free to indicate your favorite legislative provision to minus Section 15A of the International Arbitration Act, so please feel free to comment on
favorite
yours.
politician also.
Suyen, one thing that we like to think that we're quite good at SIAC is listening. So for the purpose of being a bit provocative, what about the emergency arbitration needs to change at SIAC? What tweaks, evolutions in emergency arbitration generally would you see?
I think Schedule 1 as it currently stands is quite indicative of what the rest and many of the other institutional rules already have. For there to be change, there first has to be faith in the system. For there to be faith in the system, I think litigants need to know and understand not just the number of applications that's been filed, which we hear is more than 130, but it's also a question of, and I think if it's not sensitive, how many of these applications have actually been granted. I think it's important because as we all hear it, the claimants are the ones who have the upper hand. They go into court, they go into the emergency arbitrator, they're armed with it. A respondent, like what Raj was saying, has very limited time to respond. So when the tribunal, when the emergency arbitrator who is sitting there grants that order, a party needs to have faith that this standard that the emergency arbitrator applies is one which is strict. It is not given as a matter of course, and that it is only in extreme and exceptional circumstances that they grant an emergency arbitrator order. And then, when parties have faith in the system, you can then have rule change where you could even say that the emergency arbitrator has, in exceptional circumstances, even the power to grant ex parte relief. And that is one of the tweaks that I foresee in the future, but I think there needs to be more faith in the system, because I think some sort of companies or some clients, they are so concerned about it, and they say, and they may even go to the extent of excluding emergency arbitrator provisions from the adoption of institutional rules, because they are concerned that they are at sort of the losing end. So that's what I think we may see. And sorry, I should add one more thing. You have within Schedule 1 that provision for security for cause. So an emergency arbitrator, in granting the claimant that advantage of the emergency relief, actually has that power to make an order for security for cause. And we know how difficult it is in international arbitration to get an order for security for cause, because everyone says when you enter into a contract, you know exactly the financial situation of the counterparty. So should emergency arbitrators then, having given the claimant that benefit of that order, be robust to make orders for security for cause at the same time, particularly in situations where it may be abused as a tactical tool? And if you see arbitrators, emergency arbitrators, more prepared to make these orders for security for cause, again, I think it adds faith to the system that this is really a relief that is more out of the ordinary and not matter of course. Yeah.
Do you think the standard for the grant of interim relief should be ensconced within Schedule 1, or is it better to keep it flexible?
I actually do believe that there is an international standard emerging, and I see that international standard emerging as being a good one, that it is really a question of irreparable damage. That sort, and it must be irreparable in the sense that it cannot be compensated by pure monetary compensation. So it is something that I think it would be I don't think that standard should be in an institutional rules. And it is something that we all understand. I think also parties can start to get creative with their emergency arbitration application. So certain instances, even in a non-investment arbitration cases, you can take out relief for non-aggravation of a dispute. So I think commercial parties can also think of that, as one of the things that may be useful. And because of that so multitude of circumstances, I just think it would not be wise to put the standard inside an institutional rules, but generally when we look across the board, I do think that there is this international standard emerging.
And it's interesting as well, because you have the standard for the institution accepting, and then the standard for the grant of interim relief from the emergency arbitrator.
Yes.
You will see from our statistics that all 134 applications have been granted in that we went
They
ahead with
accepted
the
it.
appointment of the emergency arbitrator, which to me may be the better way to do it. Any other closing observations on emergency arbitration, or what SIAC might want to consider going forward?
Yeah, well, there's one controversial point, which is whether emergency arbitrator should grant ex parte injunction. Right? Of course, as it stands now, there is no power to grant it on an ex parte basis. The UNCITRAL 2006 model law has introduced Article 17, I think, if I'm not wrong, C or D, I can't remember which letter of the alphabet it was, where the arbitrator actually can grant a preliminary order on an ex parte basis. Singapore, when we review our model law, we decided not to adopt it, because I think the idea is that there must be it's a consensual system, and it is going a bit too far to say that you can grant an order on an ex parte basis. But I think it's time to think about it, and it's time to consider it, because there are situations like Suyen say, where ex parte order may be necessary, right? For example, in a Mareva injunction kind of situation. And I'm not sure whether it is something that SIAC can provide for under the rules, okay, whether parties can then subscribe to the rules and say that you can grant, since the law doesn't say that you can do it. And I can see attempt being used, of course, to challenge that on the basis of a breach of natural justice. So it does have a lot of issues, but it's certainly something that I think we should be thinking about.
I fully agree with that. I mean, the Swiss international rules of arbitration make provision for preliminary orders. in exceptional situations. And I agree with what Ilyong said. I think, it's something to look at. There's some situations which really require ex parte, partly maybe because of speed, but mostly because you don't want to give the other party notice so that they end up dissipating their assets, or if you're trying to stop them from doing something, they do the very thing you're trying to make them stop doing, simply because they know about it. So it's high time, I think, arbitral institutions think about this. And the concern is natural justice and, and the consensual process and all of that. But, the arbitral rules have moved on. One good example of how it's moved on is the, expedited procedure under the SIAC rules, where in your contract you can talk about having a tribunal of 3, but if you under the SIAC rules, if it falls within the 6 million threshold, it can be removed and sort of rearranged and reorganized to a single seat tribunal. So, and there were challenges before that's not, that's something that goes against the composition of the agreed composition of the tribunal under the New York Convention. But ultimately, it's prevailed. It's prevailed because the argument which should work is that when you sign up to arbitral rules, if the arbitral rules say that in certain situations ex parte relief can be allowed with some safeguards and so on, it's then quite difficult, I think, for you then to try to set it aside on the basis that there's some breach of natural justice or something along those lines. So this is something I think the arbitral community should work towards. It would be a very good development.
So in India, I think this is one situation where maybe we can trump Singapore. If obviously under the Indian law, both the parties under Section 18 are required to be treated equally. Under Section 24, notice is required to be given to both sides. Both parties should have the notice for the hearing. But under the Indian law as well, if a recalcitrant party does not turn up, does not honor that notice, then certainly the arbitrator can move forward on a ex parte basis. So if you were to marry the law along with the rules in an India-seated arbitration, then certainly that seems to be a possibility. It is a possibility. And I don't think any Indian court in that sense would step in to say that despite notice, a party does not appear and is recalcitrant, and yet that emergency order ought to be set aside. And there is a decision of the Bombay High Court in a recent matter of Godrej Properties where an ex parte order was set aside, but interestingly, both the parties did not get notice, and that was the reason why that order came to be set aside. But so those are exceptions again to the situation that I was otherwise talking about.
Yeah, I suppose the distinction is true ex parte, where you don't have to provide notice, and a situation where a party is not participating. I think that we are at time, but I see an intervention from SIAC court member Shaneen. Please, if.
I was going to give you the liberty of letting me tell you later, but you asked for suggestions, and I have a suggestion. You mentioned that the emergency application has to be filed along with the request for arbitration.
Yep.
Which means that is your date of commencement of arbitration. Now, if you were to allow the application to be filed in advance so that your arbitration commences later, that would take care of a situation where there is, for instance, some pre-action protocol that has to be met, but there are still interim reliefs required to be sought. So what we would normally do in a situation like that is run to court because you require the emergency application along with the request. If you change those rules, you may get more than 130 applications.
Yeah, that's not a bad idea. I mean, if you're up against a limitation period, you can make arguments both ways. ICC has that where you can make an application in front of the notice, so it's certainly something that we'll look at in this current revision. So after 2 years on every possible online platform, hundreds of webinars, instead of pressing the applause emoji or whatever that is, we now get to thank these panelists in the usual way. Please join me in giving a round of applause for these panelists.